Hello and welcome to another edition of Coffee Talk with immigration attorney Brian D. Lerner. In this set of videos, we're learning about E-1 and E-2 visas. In this particular video, I'd like to discuss some specifics of the E-1. Now, the E-1 deals with trade. So what is trade? Well, trade is defined as the existing, and notice that's existing, not the future, but the existing international exchange of items of trade for consideration between the U.S. and the treaty country. Domestic trade is not counted when considering substantial trade. So, items of trade can be all kinds of different items. It doesn't have to be an actual product, although it could. It is not limited to goods, services, international banking, insurance monies, transportation, communications, data processing, advertising, accounting, design and engineering, management consulting, tourism, technology, and its transfer, and news gathering. So you can see it goes wide over the board what it is. I mean, it also includes data processing, and management consulting, tourism. It just goes all over. Now, goods are tangible commodities or merchandise which have extrinsic value. So whatever's being traded has to have some value, and the services which are traded must have legitimate economic activities which provide other than tangible goods. So again, you might not even have an actual product that's trading back and forth, but a service will do if it meets within these requirements. Now, the trade must be principally between the U.S. and the country of which you're from, of which there's an E-1 treaty, meaning, you know, you can trade in other countries, but principally it must be between those. So more than 50% of the total volume of international trade must be between the U.S. and the treaty country. Now, again, keep in mind that domestic trade is not counted in that calculation. If the business does more than 50%, then each E-1 owner does not need to own more than 50% trade. Okay? So, if it is only a U.S. branch office, then the foreign company has to have more than 50% of its trade with the U.S., since it's not considered a separate legal entity. So keep in mind, if you're, like for example in the Philippines, and trading back and forth with the U.S. and you open up a small branch office, you have to show that that office in the Philippines has at least 50% trade capacity with the U.S. Okay, more in the coming videos.